こんにちは。ベーカーのマッケンジー法律事務所パートナーのMasumotoです。本日は前回に引き続きまして、国際仲裁ビデオシリーズ東京ミーツタイランドと題しまして、バンコクオフィスのパートナー、Pumma Doungrutana弁護士とアソシエイトのKositプラシトベロージュ弁護士を迎えましてお届けいたします。なお、前回と同様、英語で進めてまいりますが、最後に私より簡単に日本語で要約をさせていただきますので、最後までご覧になっていただけますと幸いです。So, Dom, Pumma, and Kosit, please continue your conversation.
ありがとうございました。So, thank you so much again, Pumma and Kosit, for your time. Just carrying on from the last session, can you let us know about any current trends or news in Thailand that you think might be of note?
Yeah, sure. Let me start with TAI. They have been rolling out some interesting initiatives. In 2023, TAI amended its rules to allow the use of expert conference, so-called hot tubbing. Hot tubbing takes place when expert witnesses are questioned together in a joint session. The expert conference is common in international arbitration, but for Thai lawyers, it is a new approach for obtaining expert opinions. This development is a sign that TAI has always enhanced its rules to modernize and align with global practices. In 2024, TAI rolled out a new set of rules that it allows itself to act as an appointing authority. What's interesting is that these rules allow TAI to support arbitrations that follow other frameworks like the UNCITRAL arbitration rules. This move clearly shows that TAI is opening its door wider to international arbitration. It's a strong signal that Thailand is serious about being part of the global arbitration community. Just recently, in August 2025, TAI launched its new mediation center called TAI-MC. It has been built by adopting the ARB model, similar to the SIAC-SIMC protocol. Basically, parties start with arbitration, pause for mediation, and if that doesn't lead to a settlement, they resume arbitration. It is a flexible setup that gives parties a chance to resolve things amicably without stepping away from the structure of arbitration. It is still early days, but it looks like a promising option, especially for disputes where maintaining the relationship really matters.
And on the judicial side, the courts have been very supportive of the arbitration. The Thai Supreme Administrative Court and Thai Supreme Court have issued several rulings that reinforce a limited curative intervention approach. For example, the concept of the public order and good morals under the Thai Arbitration Act of 2002 is one of the grounds where the court can refuse to enforce or even to set aside an arbitral award. It is basically the slight variation of the public policy standard used in the New York Convention or the UNCITRAL model law. The losing parties sometimes try to use it as a way to litigate the case, arguing that the arbitral tribunal got the fact or the law wrong. But the Thai courts have been working to narrow that door. In 2019, the Thai Supreme Court made it clear that the public order or good morals should be interpreted as something that affects the public interest, like the public service or the common good, not just a private dispute between the parties. Then, in 2023, the Thai Supreme Administrative Court reinforced that idea. It said that this ground should only apply to the issues involving the fundamental justice or morality, not to review the merits of the case. So, if someone is just unhappy with the outcome, that's not enough to reopen the dispute. These rulings are the big step forward in protecting the finality of the arbitral award and keeping the arbitration efficient and fair. In other words, the courts are respecting the autonomy of the arbitration process and not stepping in unless absolutely necessary. That's a big confidence booster for the parties choosing Thailand as a seat. So, overall, we are seeing a clear trend. The institutions are evolving, the procedures are becoming more flexible, and the judiciary is backing arbitration. It's good time for the arbitration in Thailand, and I think we'll see even more innovation in the next few years.
That's really fantastic, and it sounds like all the moves are in entirely the right direction in terms of arbitration in Thailand. I guess maybe zooming out a little bit, but do you have any practical tips or advice for Japanese companies that are doing business with Thai companies?
Thanks, Dom. I assume that this question is in the stage of a negotiation of a contract. If you're negotiating with Thai counterparties, my first tip is be patient and diplomatic. Thai business culture values harmony and indirect communication, so a confrontational approach can be backfired. However, Thai people are sensible. With this in mind, when I negotiate the jurisdiction with a Thai counterparty, I will always trade off a governing law clause with a jurisdiction clause or a law of the seat. For example, if a counterparty wishes to apply Thai law as a governing law of the contract, it tends to accept that a Japanese jurisdiction applies to the seat of arbitration.
Thanks so much for that insight, Pumma. Actually, it sounds like Japanese parties and Thai parties are perfectly aligned in terms of patience and harmony, so that's wonderful news. Last but not least, do you have any practical tips or advice for Japanese companies that have a business or a subsidiary in Thailand as to the dispute resolution system?
Thanks, Dom. I do. For Japanese companies with Thai subsidiaries, the key is proactive planning. 1. Make sure your contract, especially with local partners or suppliers, have well-drafted dispute resolution clauses. Arbitration is often preferred for cross-border issues. Also, stay on top of regulatory compliance. Thailand's legal environment can be complex, and local practices may differ from what Japanese companies are used to. If a dispute arises, consider mediation or arbitration before going to court. It's faster, more private, and often more cost-effective. Finally, build strong relationships with local counsel. They help you manage risks, resolve disputes efficiently, and ensure your operations stay on track. Thanks, Dom.
Of course, if people just come to Baker McKenzie, then they can have counsel in Japan and Thailand. Thanks so much, Pumma and Kosit, for your time. And over to Mika now to wrap up in Japanese.
Thank you, Dom. Pumma and Kosit. それでは私から、簡単に日本語で概要をご説明させていただきます。まず、タイにおける昨今のトレンドやニュースという点につきましては、TAI の規則改正についてお話がございました。2023年の改正では、国際仲裁では一般的ないわゆるホットタビングという両当事者の専門家証人が同時に尋問を受ける方法が導入されましたり、2024年の改正では TAI が自らアポインティングオーソリティ、仲裁人選任機関となることができるようにするなど、TAI は暗視ある仲裁規則などの国際的な枠組みに従った国際的なルール作りを進めているということでございました。さらに2025年8月には TAI は TAIMC と呼ばれる新しい調停センターを立ち上げ、当事者は仲裁を申し立てた後、仲裁手続きを停止して調停に移行し、そこで和解ができなければ仲裁手続きに戻るといった 柔軟な手続きが可能となったということです。また、タイの裁判所は仲裁プロセスの自主性を尊重し、必要な場合以外は介入しない姿勢を示しているということです。例えば、裁判所が仲裁判断の執行を拒否したり、仲裁判断を取り消す根拠の一つとして、仲裁法が定める公序良俗の解釈において、タイの最高裁判所と最高行政裁判所は、公共の利益に影響するもの、基本的な正義や道徳に関わるものといったように狭く解釈をしているということでございました。このようにタイにおける仲裁制度は日々進化をしており、手続きもより柔軟になっているということです。次に、タイ企業とビジネスをする際のアドバイスといたしましては、契約交渉においては忍耐強く外交的になることがポイントであるということでございました。タイのビジネス文化は調和と間接的なコミュニケーションを用いるため、対立的なアプローチは逆効果になるということです。契約交渉においては、例えば準拠法は相手方の主張を受け入れるが、仲裁地はこちらの主張を認めてもらうといったようにトレードオフをするということが有益ということでございました。最後に、タイの紛争解決制度に関する日本企業に対するアドバイスといたしましては、タイのパートナーやサプライヤーとの契約書には紛争解決条項をきちんと盛り込むこと。特にクロスボーダー案件については仲裁が紛争解決方法として好まれることが多いということでした。また、法規制の遵守を怠らないことが大切ということでして、タイの法的環境は複雑で、日本企業が慣れ親しんでいるものとは異なる場合があるため、注意が必要であるということでした。そして紛争が生じた場合には、訴訟提起の前に調停や仲裁を行うことも検討することが良いということでした。調停や仲裁は迅速かつ非公開でコストエフェクティブである場合が多いということです。最後にリスク管理や紛争の効率的な解決、円滑な業務の遂行には、現地の弁護士と信頼できる関係を築き、サポートを受けることが重要であるということでございました。以上、前回から2回にわたって弊社バンコクオフィスの弁護士をスピーカーに迎え、タイの仲裁実務の概要をお届けさせていただきました。引き続き本ビデオシリーズをご覧いただけますと幸いです。本日はご視聴いただきましてありがとうございました。